This is Michael Popok, Legal AF. Donald Trump and his team might be in deeper hot water than we even originally thought, just by the way they have procedurally filed their motion for mistrial in the New York civil fraud case. I've done a hot take about what the motion for mistrial said. Now I'm going to do one about the procedure leading up to it and why it may put Donald Trump and his legal team in the deep fryer with Judge Engoron and above, just the way that they filed it. Now, there was reporting during the week for people that were in the courtroom that Alina Habba, on behalf of Donald Trump and the New York Attorney General, were up at what Judge Engoron likes to call a front bar, right? There's no side of his bench, so he takes the discussion at the front, away from, courtroom observers, quietly at his bench, with the court clerk, principal law clerk, sitting next to him. So there was some speculation. Well, maybe they're talking settlement. And I disabused that in some internal discussions we had over at Legal AF, having practiced in the New York court system for a long time. There was no way the judge was going to risk having a settlement discussion even anywhere in the courtroom, let alone with Alina Habba taking the lead for Donald Trump. And he would have done that in their chambers. Chambers, which is I'll give another description here, Legal AF Law School breakout session, behind the bench. In another room is the judge's office. We call it the judge's chambers. It usually consists of a long table with the judge at a desk at the top of that long table, and the lawyers sit in there, sometimes with their clients, to discuss things the judge wants to talk about off the record. I have seen, and it's totally appropriate, for judges to try to get the cases settled. They'll try to put the parties together, act as sort of a mediator or a diplomat. I just recently participated in one in the commercial division of the New York court, which is where Donald Trump would love this case to be, in which the judge threw the clients out and had the lawyer meeting only to try to promote settlement, and then brought the clients back in and made some other comments, all off the record, no court reporter. That's in chambers. And the fact that that reporting told me that they were not doing it in chambers meant to me they were not having a settlement discussion. But what we're now piecing together is that there was likely a discussion just yesterday or so about how Donald Trump's team procedurally would file their motion for mistrial. They may have, but I doubt it, previewed for the judge their attacks that were going to be contained in the motion against his principal law clerk by name, by photo, and by campaign contribution listings. All of that private information. Well, some of it's not private because it's in the public domain, but I doubt that they raised that. In any event, we believe, based on transcripts and reporting, that the legal team for Donald Trump at least committed, as officers of the court, to Judge Engoron, that it would be handled, in Alina Habba's words, delicately, the filing, okay, and that they would do it in a way, the judge suggested that they do it in a way seeking an order to show cause, which is a one-page document under New York practice, which sets up a future hearing, giving time for the judge to get a courtesy copy, let's say, of the motion and all of its attacks and pictures and photos of the law clerk, and then make a decision whether it, A, violated the gag order already in place, Judge Engoron already gagging the lawyers and Donald Trump from attacking the principal law clerk, even if it is the basis of their mistrial motion, and to look and to see if anything needed to be sealed from prying eyes of the public and media, and or redacted. And that's where we think that discussion landed, which does not now bode well for Donald Trump and his team, who decided to throw over that apple cart. And if this is Alina Habba's example of a delicate, she's about as delicate as a bull in a china shop, because they just filed the motion with the attacks on the principal law clerk, her photos, her name, her, unfounded allegations against her character, her professionalism, and her ethics as a New York bar member, and as a fellow bar member. That is in itself an ethical violation to call that out in that way and to try to use it to your advantage, in this case, for a mistrial. So I think they have an ethical problem in the way they've attacked the bar member, the fellow bar member. That's one. If I were her, I'd file a bar complaint against Alina Habba and Cliff Robert. I'd have Alina Habba's license to practice before this judge pulled. She's there, I believe, under a special admission. Get that pulled, and then sanction them for the way that they filed this. because they didn't give the judge the opportunity they said they were going to do. They just put it into the public media on the public docket without giving him the opportunity to make a decision about sealing or redaction. That is the reporting we're piecing together from the conversation at the front bar yesterday or so with Alina Habba driving it. We didn't know what was said. Some people speculated it was settlement. I speculated that it was definitely not settlement discussions, but it looks like they were talking about the logistics of filing their motion, right? The substance of which I've done on another hot take. I think this is going to be ethical violations of the gag order, and could well be grounds to further sanction Donald Trump and others, besides the fact that the mistrial motion is going to be denied. I mean, the Attorney General is going to get all hot and bothered under the collar, file their opposition papers. There'll be one more brief maybe, and then the judge is going to deny it, then moving on to the appellate division, First Department for appeals. However, the reporting here is over the procedure, and whether that now has gotten them into further hot water on the Trump side because they have misled the judge as officers of the court. I'm an officer of the court. You have an obligation to not mislead the court and not commit your own misconduct in lying to the court. Woe be them if it's determined by this judge as the trier of fact that he's been lied to. We'll know it soon because he'll call for an evidentiary hearing and he'll make a big deal out of it in the courtroom. We'll follow it on Legal AF, the leading podcast at the intersection of law and politics. We do it every Wednesday and Saturdays. Join us on the podcast, 8 p.m. Eastern Time on the MeidasTouch Network on YouTube. Give me a thumbs up for this particular update and content. And until my next hot take, my next Legal AF, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.